Welcome back to another episode of Between Two Fars. I'm Warneke Miller, and I have been joined by Brian Stanford. He is a senior attorney advisor at headquarters and is specializing in procurement law. Particularly, we've been talking about the differences between litigating in front of the GAO and litigating in front of the Court of Federal Claims. All right, we got a big one today. The thing the clients are all nagging us about, Brian. Schedule. What is the difference between COFC and the GAO with schedule?
It's a huge question, Warneke. Yeah, we get it a lot from our clients. Okay, we're probably going to get a protest, or we may get a protest. We probably will get a protest. We have a protest. What's this going to do to our schedule in terms of being able to award or start performance of a contract? And traditionally, one positive attribute of both for the government and for the protester of going to the GAO and filing a bid protest there is that you have kind of a bounded time for the litigation and the decision. So GAO is mandated to issue their protest decisions within 100 days of filing, or otherwise tell Congress why it's not going to do so. And I don't think I'm not aware of any exceptions to that 100-day mandated decision timeframe. And the timeliness rules for GAO also are very prescriptive in when the agency has to respond and when the protester has to respond. So for the agency, our agency report, which is our memorandum of law, our contracting officer statement of facts, the record in the case, everything that is the agency's response in defense of the bid protest has to be filed within 30 days from the date at which the protest was filed. And then the protester has 10 days from receipt of that agency report and agency record to file any supplemental protests and comments that are derived from that report and that record. So everything is bounded very nicely. COFC, when a protester files at the court, it's all kind of case by case specific, and it's subject to a lot of horse trading between the litigants and discussion with the judge. We have a status conference, and the judge usually asks the United States, okay, well, when do you need this case decided by? And the answers are always categorically, from the agency as soon as possible, so that we can move forward. And so I think the perception in the legal community for many years was, oh, if you go to a Court of Federal Claims, you could be bogged down in litigation for an inordinate amount of time. And I actually don't think that really hasn't been my experience. My experience has been that the Department of Justice attorney and the judge in the case, as well as opposing counsel, are usually able to kind of work out a schedule that fits with all the parties' desirements for moving forward. And pretty categorically, personally, in my experience, the Court of Federal Claims is those protests usually get decided around 100-ish days from filing. So in actuality, unless there is a unique issue or barring some other irregularity, if there's additional discovery in the case, usually the judge, especially if the agency is willing to voluntarily stay performance of the contract, the judge will do his or her best to ensure that a decision is reached and documented and publicized, in a very expeditious manner so that the agency can move on. There's no strict time limit. The court could issue a decision whenever it wants to. But again, in my experience, that has not been the case, and the court has been amenable to making sure the agency can get its decision, whatever that decision may be, and move on from there. Again, it's we can get into the difficulties that may arise when deciding when agency counsel and the Department of Justice counsel are talking about whether it makes sense or not to voluntarily stay or fight the preliminary injunction, kind of what that does to the schedule of the case. Yeah, that's kind of the differences, or maybe lack thereof, differences in the schedule of the litigation until you actually get a final decision.
Thank you. That's very helpful. I think very reassuring to some of our clients to know that the timelines may kind of run neck and neck with each other.
Yeah.
We've got so much more to talk about. Would you join us again for another episode so we can keep talking about these differences?
I'd love to. Thank you, Warren.
All right. We'll see you again next time between two FARs.